Hey everyone, this is Attorney Carrie from the Law Office of Carrie Nguyen with this week's important immigration updates. If you're not a U.S. citizen, you've probably heard something about the new alien registration requirements that went into effect on April 11th, 2025. Don't panic, we're here to break it all down for you. Let's start with who does not need to register under the new policy. U.S. citizens and people who are in the U.S. for less than 30 days. Easy, right? Now, what about everyone else? You might already be registered or already registered without realizing it. And if so, you all set. You don't need to do anything extra if you fall into one of these categories. Permanent resident, or what we also know as green card holders. People with any kind of parole or an I-94, like a humanitarian parole, advanced parole, a military parole in place, even if their state or status has already expired. People who had a valid visa when they last entered, unless you were under 14 years old. So what that means if you enter with your parent and you were less than under 14 years old, you may have to re-register. People who are currently awaiting removal proceedings, no worries, you are registered. Anyone with a work permit or a border crossing card are already also registered. Anyone also who filed for legal permanent resident through the adjustment of status process and have completed their biometrics are already registered. So who is required to register? Basically, everyone else who doesn't fall into the previous categories I mentioned. In particular, if you have a pending adjustment of status, a U visa application, or a pending or approved I-601 unlawful waiver present, and you have not done your biometrics yet, you do need to register. Not sure if you should do it or not, you're not alone. We recommend talking to an immigration attorney before taking action. There are risks and benefits to registering, and it depends on your case. So let's figure it out together. Did you receive an email saying that you must leave the United States immediately on Friday, April 11th? That kind of message can feel very scary, but don't panic. We're here to help you understand what it really means and what your options are. This email came from the Department of Homeland Security and stated that your parole, the temporary permission you were given to enter the United States, will be ending in 7 days. It warns that if you don't leave voluntarily, they may take legal action. We want to be very clear. You're not the only one who received this. It's a mass notice that went out to many people. And just because they asked you to leave doesn't mean you are being deported or that you must leave right away. Everyone who entered with parole received that email. They're asking you to leave voluntarily. If you have already another immigration process pending, this notice does not cancel that. So if you choose to stay and fight your case, or wait for the adjudication of your case, it will not hurt your pending application. Before you make any decision to leave voluntarily, we encourage you to talk to an immigration attorney to see what's the best option for you. We're here to protect your rights and guide you through this. If you have questions, if you're unsure about your case, or if you just want a peace of mind, please give us a call. You're not alone. This is definitely a stressful time, but with the right legal support, you can stay and keep fighting your case. Thanks for trusting us. We got your back. Did you know that what you post on social media could now affect your immigration status here in the United States, especially if it's related to anti-Semitic content? Yes, it's serious and is happening right now. U.S. Citizenship and Immigration Services, also known as USCIS, just announced a new policy. They are now considering anti-Semitic activity, including stuff posted on social media and physical harassment of Jewish individuals when deciding whether someone can stay in the U.S. or even get a visa. This affects international students, people applying for the green cards, and anyone connected to schools or organizations that are tied to anti-Semitic activities such as protests on campus. Basically, if someone is seen as supporting anti-Semitic terrorism, such as a group like the Hamas, even online, that could be enough to deny the immigration request. This move follows executive orders that started under the Trump administration, focusing on national security and fighting anti-Semitism. The Department of Homeland Security is making it clear the U.S. will not tolerate extremist views that support anti-Semitic violence or terror. If you are on a visa or are planning to apply for one, take this as a wake-up call. What you post online matters a lot. Stay informed, stay respectful, and even if you have questions about your status, talk to an immigration attorney. This is about way more than politics. It's about your future. There have been a lot of immigration stories to show just how unpredictable the system has become, even for those who follow the rules. If you think about having an approval or a court order to protect you, think again. Hi everyone, I'm Attorney Carrie Nguyen, and in this video, we will highlight a controversial case of a DACA recipient, Mr. Ebenezer Cortez Martinez, who was deported after traveling with advanced parole. He followed all the proper steps got the government approval to travel, and still wasn't allowed back into the United States because CPP said he had a prior removal order, something that should have been caught, but he was approved to leave. Instead, they claim his advance parole was issued in error and deported him on the spot. Luckily, he was finally back home after the scary experience. This story sends a clear message. Even when the law is on your side, mistakes, miscommunication, and suddenly policy shift can put your status at risk. And it's not just happening to undocumented. It's happening to DACA recipients and to people with granted relief from deportation. That's why at our firm, we're committed to staying ahead of these changes. We are carefully reviewing every detail and actively tracking policy shifts to ensure nothing slips through the cracks. With so many certain changes to immigration policy, it's crucial to have a team that's prepared and proactive. We understand how much is at stake, and we're here to fight for your future. If you have advance parole, DACA, or any pending immigration case, reach out to an experienced legal team. Let's make sure you're protected from unexpected setbacks and policy changes. Make sure to like and subscribe. If you have questions, leave them in the comments below. Wait, what if filing your taxes could actually get you deported? Sounds unreal, right? But that's exactly what's happening behind closed doors. Hi, I'm attorney Carrie Nguyen with the Law Office of Carrie Nguyen. And according to reports, the IRS has finalized a deal with Immigration and Customs Enforcement, also known as ICE, that would allow immigration officials to get confidential tax data. Yes, you heard that right. Under this agreement, ICE will be able to submit names and addresses of people suspected of being here undocumented, and the IRS would check its databases for any tax records tied to them. Now, here's why this is a big deal. Under federal law, the IRS is supposed to keep taxpayer information private under Section 6103 of the Tax Code. It aims to protect data unless a court signs off an exception. It's there to keep the IRS non-political and focus on taxes, not immigration enforcement. For years, undocumented immigrants have been filing taxes and have been encouraged to file taxes under something called an I-10, an individual taxpayer identification number. They pay billions in taxes to the US government. In fact, one study shows that they pay $25 billion to Social Security, and a lot of them do not benefit from any of this. Now, that same tax information can be used to target them. Stay informed, speak up, and if you or someone you know files with an I-10, now it's time to connect with a trusted legal team. Subscribe here for updates and how this will impact the immigrant community. Are you transgender, non-binary, or gender non-conforming and dealing with immigration paperwork? This update could seriously impact you or someone you care about. On April 2nd, 2025, USCIS released a policy alert that affects how they process immigration documents when it comes to sex or gender. Here's the bottom line. USCIS only recognizes two biological sexes, male or female, for the purpose of reviewing application and issuance documents. They will go by what's listed on your birth certificate, specifically the certificate issued at or near the time of your birth. If your birth certificate is missing that information or shows something other than male or female, they will use secondary evidence, but they will not leave the sex field blank on your documents. Also, if there's a mismatch between the sex on your birth certificate and when you put on your application, the birth certificate takes priority. USCIS will deny your application just for not selecting male or female, but it also could delay your case if there's a difference. USCIS is also replacing the word gender with sex across its policies, and they're removing previous guidance that allow doctors to confirm someone's gender identity for immigration purposes. If this policy impacts you or someone you know, groups like Immigration Equality and the ACLU want to hear from you. They're tracking delays, deniers, and other issues caused by this update.